The GB was able to join that.
Oh, okay.
Yeah.
Nice.
Christine Tenorio.
All right, we're good, we're really good.
Okay.
We'll start. All right, Hafaday Todos Hamza, for the record. My name is Master Judge Jonathan Kwan. I'm the chairman of the Criminal Law and Procedure Review Commission. We are here for a plenary meeting of the commission. It is now 12 p.m., June 13th, 2024, and this meeting is called to order. I note for the record that we are, I note for the record, we are in person in the Judge Joaquin B. Maribusan Senior Memorial Courtroom in the Judicial Center. We are on Zoom for those members who are not able to attend in person. We're also live on the Judiciary's YouTube channel. As this meeting is being recorded, to avoid background noise, I ask members appearing by Zoom, please mute yourselves unless you are speaking. And if you are here in person, please wait until we position the microphone or indicate to you before you speak. All right, at this point, let's move on to item 2 of the agenda. On agenda item 2, due notice. I note for the record that due notice of today's meeting has been provided pursuant to the requirements of the open government law. Copies of the newspaper notices are included in your packets. On agenda item 3, quorum. We'll start with a roll call. Members who are here, when your name is called, please state present and the location you are appearing from. May I ask the executive director or the compiler of laws, Jerry Cepeda, to please call the roll.
Honorable Jonathan R.
Present, Judiciary Guam, and again.
Honorable Maria T. Senzon. Honorable Anita A. Sokola.
Present here in Tonghun, Guam.
Attorney William Bucky Brennan.
Present at the Judiciary in the government.
DOC Director Fred Bordalio.
Present here in the Judiciary and again.
Designee Major Anton Elgin. Chief of Police Stephen Ignacio or Designee Lieutenant Ron Titano. Attorney Joseph B. McDonald.
Present, Sinahanya, Guam.
Attorney F. Randy Cunliffe.
Present on Zoom.
Mr. Monty McDowell. Attorney Stephen Nattori or Designee Attorney John Morrison.
John Morrison, present from Sinahani, Guam. I wanted to let the courtroom know I'm having some trouble hearing. I'm not sure if the other people on Zoom are having a similar problem, but it seems really light.
Yeah, it's very, very quiet.
Attorney General Douglas Moylan or Designee Assistant Attorney General Stephen Cody.
Stephen Cody, Nathan Tennyson, President Judiciary.
Attorney Mike Phillips.
Present on Zoom.
Ms. Valerie Regis. Attorney Christine Tenorio.
Present at my office in Tumbling, Guam.
Attorney Phil Tidinko.
Here in the courts.
CLRC Executive Director Serge Kenga.
Present at the court.
I'm the compiler of laws, Jerry Cepeda, and I'm present here at the Judiciary of Guam.
Mr. Chairman, if I may, I'm seeing 10 appointed or designated members, official members of the commission present.
We need 8, right?
We need 8 for quorum.
Thank you. We have a quorum and we can conduct the business of the commission at this meeting. At this point, do we have any ex officio members present?
Ryan Eggleston,
Mr. Eggleston is present.
was Judge E. present?
Judge EBA present at home.
Your Honor, good afternoon. Thank you. I'd like to welcome the ex officio members and I thank them for their participation today. All right. Agenda item 5. Old business, please put up slide 3. I'm sorry. I see, I apologize. Agenda item 4, minutes. We have the plenary meeting minutes of April 4th, 2024 for approval. These minutes have been provided in the meeting packets that were given to you earlier for the members' review. May I have a motion to approve?
I move to approve.
Is there a second? Any opposed? There being none, the minutes are hereby approved. Move on to item 5. Agenda item 5, please put up slide 3. May I ask the executive director to provide the status update and report? Mr. Executive Director.
Thank you, Mr. Chair. This is an informational item to report. I'd like to report that the 2024 first quarter report was submitted on May 7, 2024, and is posted for review by the general public. I encourage everyone, all the members, ex-official members to take a look at that. If you have any questions or comments on it, please let me know. As far as work by the subcommissions, work is continuing on the assigned chapters. But as we all know, we do have a large number of chapters left to review. We do understand and recognize the huge difficulty our members have in finding time to participate in subcommission working sessions to review chapters. However, we encourage all members to work diligently. Remember that without the work of the members, you who are our criminal law subject matter experts, the CLRC will not be able to fulfill our mandate to review Guam's criminal statutes. I am always available for any assistance in convening working sessions or with any other issue. Please contact me at any time. I'd like to move on and update the commission members on our fiscal year 2025 budget request. We have submitted as our budget submission to the judiciary status quo request. This will enable us to continue into the next fiscal year. We've also submitted a proposed amendment that will allow us to extend the time to submit the final report of the commission. You may recall that our final report was to be due 24 months from the initial meeting of our commission. The initial meeting of our commission was January of 2023, which gave us originally until January of 2025, which we're rapidly coming up on, which is why we still need to work as diligently and quickly as possible in reviewing the chapters. If we do get the amendment passed, then we'll be able to extend the reporting requirement an additional 24 months. With the total time for review of all the criminal laws of Guam being 48 months or 4 years. We've had to ask for the amendment of the budget to continue the work of the commission, because as we all know, it's been very difficult for our members, as I said earlier, to meet in working session. I guess we can't understate the importance of everyone's participation. Knowing how difficult it is for you all to meet. We know you're practitioners, you've got your clients, your regular caseload. Many of you are getting criminal appointments. And so I know that you're incredibly busy with your professional lives, but you've also got your personal lives and your families to take care of. So we understand that. But if you need any assistance whatsoever, let me know. I'm willing and available anytime to assist. Thank you, Mr. Chairman. That's all I have to report.
All right, I'd like to add that, I understand most of the chair. Yes. All right, I want to thank, everyone present and everyone who's worked. I understand, for all of you, this is volunteer work, to make the system better. And I understand that, you're doing this as public service, and I want to thank you all for that. I would estimate we're about halfway done in terms of the sections we have to review. So we're trying our best, and I appreciate everything you've done. Anything further? It's Executive Director. All right. Let us move on to item 6, subcommission presentations. Please put up slide 4. Can we get an update from the subcommission on drugs and other criminal offenses? I believe Judge Senzon is the subcommission chair. However, I think she's caught in hearings at this point in time. So,
Thank you, Mr. Chair. I am reporting, this is Jerry Cepeda. I'm reporting for Judge Senzon. We do continue to work on it, and we have before us the revisions of the parole statutes. We will be working on, we will be calling another meeting of the subcommission. Scheduling has been challenging, but we do continue to move forward and perhaps communicate by email going forward in addition to in-person meetings.
all right, we'll have to table the subcommission on drugs and other criminal offenses presentation for later time. Let us move on to slide 5, which is going to be the subcommission on criminal procedure. At this point, Madam Subcommission Chair Judge Sokola, you have the floor, ma'am. Judge Sokola.
Yes. Can you hear me now?
Yes, ma'am. Good
All
afternoon.
right. Good afternoon, Mr. Kwan. Good afternoon, members of the commission. We're going to continue with our discussion, and I believe it's on chapter 7. And Mr. Serge Kenga at this time will go ahead and give a presentation of what we have been discussing this last 2 to 3 weeks since our last meeting. Mr. Kenga, please.
Thank you, Judge Sokola. Can everyone hear me fine? If you can't hear me, please let us know and we'll try to do better.
Hold on. Restart voice meter. Let's try that. Restart voice meter. Thank you. Testing 1, 2, 3. Testing 1, 2, 3. Good. What about this one? Testing 1, 2, 3. Testing 1, 2, 3. Oh. Testing 1, 2, 3. Testing 1, 2, 3. Testing 1, 2, 3. Let's proceed.
Okay, I'll start again. Thank you, Judge Sokola. On behalf of our subcommission, which includes Assistant Attorney General Stephen Cote, Public Defender Brian Eggleston, and alternate Public Defender Lenny Rapadas, we present for the Commission's consideration our recommendations covering Chapter 7, which is exemptions and defensive. Okay, so this is a very heavy chapter covering mental disease and insanity,
defenses and affirmative defenses, self-defense justification, and the castle doctrine, among others. I'd ask our criminal procedure members who are present to please feel free to jump in anytime during this presentation. Now, although I have a lot of slides, most of the amendments we recommend here are not substantive, and I plan on going through the sections pretty quickly. On the other hand, for some of the more complicated parts, we are recommending to table them for a deeper dive in working sessions with any member here who takes a special interest in the sections. We hope to stimulate discussion here on any of the sections presented, as many of you members have had experience with this chapter in your trial practice. Again, we'll table any section for detailed discussion in working sessions with you and bring them back to the big commission at a future plenary meeting. Okay, Article 1 exemptions. This is a one section article, section 710, exemption from criminal liability due to juvenile status. So as you can see in our comment, this is a non-substantive change to the title of the section. We've changed it from juvenile to minor so that it reflects 19 GCA Chapter 5, which is the Family Court Act. The Family Court Act was adopted, I think, in 1983, which was several years after this Chapter 7 was enacted by Public Law 13-175, I think it was, by the legislature. So this is simply to make the terminology consistent with the Family Court Act. Can we go on to the next slide, please? Starting with Article 2, mental responsibility. Section 716, we have no change to recommend. On 719, mental disease or defect, we've changed the title to replace the word sane with mental disease or defect, which better reflects the line of similar sections here. I think we've made it our practice to try to clarify the titles and remove the word sane, which was part of the original way the compiler or whoever the original drafter was entitled these sections. But this is again a non-substantive change to the section title. Thank you. Sections 7.22, same thing, non-substantive change to the section title. Section 7.25, psychiatric examination and procedure. Although we are recommending no change here, we'd like to offer this up for discussion to the members of the commission. This is the authority for a judge to appoint a psychiatrist or qualified person if a defendant has pled not guilty by reason of insanity. I've referred this section to the Judiciary's Client Services Division. I will report back to the commission if they come back with any comments or thoughts on this. So I open it up to anybody who'd like to comment.
Yeah, Phil Tidinko here. I think there needs to be a little bit of updating of this. As we've known in practice, oftentimes it's clinical psychologists that are brought in to testify as opposed to MD psychiatrists. So I'd like to at least be able to provide that input that I think that represents more real world practice. Thank you.
So what you're suggesting is a change, for further discussion, a change on subsection 7.25A to change that to, in the parentheses, psychologist.
Yeah, it looks like it restricts it only to psychiatry.
I see. Okay, thank you.
So what I'd like to do is table this, Mr. Chair, so that we can call a working session.
7.25, okay.
And we'll invite other members of the commission, not just within our own subcommission, to attend and participate. This might generate a lot of discussion at a working session. All right. Next page, please, Jerry. This continues 7.25. Okay, on to 7.28. acquittal order for civil commitment. We have no change to recommend here. The comment here simply is a reference to what's cited in the section, 10 Guam Code annotated chapter 82, which refers to mentally ill persons. On section 7.31, we're recommending a non-substantive change to the section title. Next slide, please. Seven point three four acquittal, court order of commitment or release, petition for discharge. This is one of the sections we'd like to table for discussion at a working session. We'll go through this. Next slide, please, Jerry. And I'll explain why we'd like to table it. So we've highlighted subsection C here. Go on to the next page, please. And the next page. Oh, yes. Okay, so this is the last section, subsection F of 7.34. It's highlighted because, as you can see in the comment below, we've copied and pasted a note from the original compiler comments. This was inserted many years ago by the drafter, and it states, note, however, that section 7.34C and possibly 7.34F are of doubtful constitutionality. And then it sort of cites to a Maryland Supreme Court case. I've tried to find a Maryland Supreme Court case that intimates or says that these two subsections are unconstitutional, but I was not able to. I found a couple of cases, and the question that's raised is whether a person acquitted for insanity can be held longer than the sentence that may be imposed for the crime that was charged.
Yeah, I think you should table it. I
Right.
think there's a lot of discussion in this area. Other states, it's not a matter of the term. It's once you go into the involuntary commitment, civil sort of status, then you're subject, at least other jurisdictions, subject you to the civil rule. The civil rules for purposes of your further commitment. In other words, like when I was in Hawaii, the folks who were acquitted but committed to the state hospital had these evaluations every 90 days up to 180 days to determine whether they should be further treated or not. So we may have to take that tack and look at other states.
Thank you, Bill. You can go on to the next page here. So I've included here the New Jersey statute, which is one of the source statutes that was relied on when our law was adopted. And the highlighted part here might be a little bit telling for us, and we can look at this further in a working session. But it does state the defendant's continued commitment under the law governing civil commitment shall be established by preponderance of the evidence. I have this underlined. During the maximum period of imprisonment that could have been imposed as an ordinary term of imprisonment for any charge on which the defendant has been acquitted by reason of insanity. So again, we'll revisit this in a working session. I'll invite all the members. I encourage you to please attend the working session. We'll probably have it in person at the San Ramon building. Okay, next slide, please, Drew. 7.37, mental disease of art and proceeding or sentence. Just a typo correction. Next slide. 7.40, same sort of non-substantive amendment to the title, removing the word same. Next slide, please. Same thing here, non-substantive change to the title. Next slide, please. This is 7.34. Okay, section 7.46 and section 7.49, non-substantive changes to the section titles, as well as citation clarification. So these are all non-substantive amendments. Next slide, please.
7.52, transfer of persons off island. We have no change to recommend here. On to Article 3 defenses. So I'll just go through these slides. 7.55, we've got a, what I think is a non-substantive change to the title. I'd like to point out that the original title here says specific defenses defined and allowed, and that was it for the title. However, the section itself addresses only ignorance or mistake, so it didn't really make sense. We're looking back at the source model penal code section 2.04. That one was entitled ignorance or mistake, and so we just took the title from there and put it here. A non-substantive change, it better describes the section. Next section, intoxication, no change here. Next slide. 7.61, duress or necessity, no change. Next slide, please. 7.64, again, a change to the title to better describe the content of the section. 7.67, the original title here was or is appropriateness of prosecution, which at least in my mind is a little difficult to understand. This section here, 7.67, comes from Model Penal Code section 2.12 and is, as far as I can tell, either identical or very close to being identical to the Model Penal Code section, which is entitled de minimis infraction. So better, we think, to call it what it was in the Model Penal Code. 7.70, entrapment as affirmative defense. To be consistent with the prior sections, we're going to we recommend removing affirmative defense because it is described within subsection A here as an affirmative defense anyway. 7.73, entitled specific defenses defined and allowed ignorance or mistake, intoxication, duress, compulsion, consent, de minimis infractions, entrapment, and renunciation. The only thing that's covered under this section is renunciation. So again, maybe a misnomer, but this just clarifies what the section covers. Next section, please. Okay. Jerry, can you back up just for a quick second? So, although in this Article 3, we don't have any substantive changes to recommend, we did spend a lot of time going through these sections. It was a little confusing to us that certain sections identified the defenses as affirmative defenses when others did not. But we do believe that was intentional by the legislature. For example, mental disease, duress, entrapment, and renunciation are especially stated in those sections to be affirmative defenses, whereas ignorance, consent, and de minimis infractions are not stated to be affirmative defenses. Again, we think that this was intended, and the Guam statutes are not exactly in line with their source Model Penal Code sections. And we do note that Section 9021 of 8 GCA. And Jerry, if I can ask you to go to the very last page of the PowerPoint presentation real quick. Okay, AGC 9021. This provides the approval of each element, offense required acceptance for negation of defense and affirmative defense. So subsection C provides subsection A does not apply to any defense which a statute explicitly designates as an affirmative defense. Defense is so designated must be proved by the defendant by preponderance of the evidence. So even though we were wondering in our subcommission, the differences in the defense sections in that Article 3, we do believe that it was intentional. If there's any questions or comments from the commission, we welcome them now. If not, Jerry, can you go back? Sorry, I think that was slide 32. Slide 32. Okay. Thank you, Jerry. So now we're on Article 4 justification. This Article 4 and the next article, Article 5, we'd like to recommend and table these for further discussion in the working session. We think that we should give this special attention because there could be conflicts between Article 4 justification and Article 5 castle doctrine that deserves some really deep dive by our experts here on the commission. So just going through Article 4 kind of quickly. Justification, Jerry, can you go back up one more time? Right, okay. So 7.76 defines deadly force. 7.78. We don't have any changes for these to recommend at this time. We do want to point out, though, that there is a curious old compiler comment and a reference to 8 GCA section 8522, which I believe it was Mr. Troutman who said that justification is not as stated an affirmative defense provided in a GCA section 8522, but that section doesn't exist. And as you see here in the pro comment, you confirm this with the compiler. I don't know if it ever existed. That's the question that I was trying to find out. So I don't know, but we'll recommend that the pilot look at this and probably strike it. I don't know. I think the section speaks for itself. 7.78. In a prosecution for an offense, justification as defined in this article is a defense. So clearly it's a defense and not an explicitly stated affirmative defense. Anyway, I thought I'd just point that out. Next slide, please, Kurt. So justification also includes necessity. Next, please. Execution of public duty. Next slide. Self-defense. Here are some exceptions to self-defense. Next slide, please. 7.86, this is the exceptions to self-defense. I do want to note, since we'll be looking at this more in a working session, that the highlighted part here, 7.86B2 sub A, the defendant is not obliged to retreat from his dwelling place, place of work or vehicle, unless he was the initial aggressor or is assailed in his place of work by another person whose place of work the defendant knows it to be. This is the only amendment to Article 4 that was made by the Castle Doctrine Act. No other parts of Article 4 were amended. It was just something for us to keep in mind as we go into the working session. Next slide, please. 7.88, just a clarification to the citations here. 7.90, another justification, force in defense of property. Next slide, please. This continues it with a citation clarification. Another justification is use of force in law enforcement. This continues 7.92. Again, okay, 7.94, use of force by person having special care. Another type of justification. Next slide. Next slide. Okay, 7.96. This provides an exception. I just noticed this when I was preparing for the presentation, that there appears to be a problem with the title 7.94 and 7.96 when the first line says justification afforded by section 7.84 to 7.92 inclusive. So we'll work on this with the compiler to get a correct citation. We'll look at the original law, but we don't have any other changes to this. 7.98, another justification, seizure of property. And that brings us to Castle Doctrine. Again, the question is, do some of the Article 4 justification sections conflict with Castle Doctrine? And I'll go through Castle Doctrine pretty quickly here. 7.112, home protection. Next slide. Very importantly, 7.113, immunity from criminal prosecution and civil action. Next slide. And the last section in Castle Doctrine is severability. Next slide, Chair. So what I thought I'd do is do a quick artificial intelligence comparison between Articles 4 and 5. And part of it I've posted in this PowerPoint presentation for your consideration. If you haven't already used ChatGPT or Copilot or the Adobe feature, artificial intelligence feature, they're quite useful, I think. But with any AI review, you should review it with your own human intelligence. Trust but verify is one way to put it. So anyway, this ChatGPT comparison starts off with the scope of the articles, points out the duty to retreat legal protections. Next slide, Chair. And then it goes into the differences between the two articles. It points out the principal parts of Article 4, justification, scope and purpose, general self-defense, limitations, civil remedies, necessity and execution of public duty. Next slide, Jerry. Article 5, Castle Doctrine, again, the same sort of information here. Under 4 legal protections, this is it points out the immunity provided in Article 5. And a summary of the differences between the two. So this is kind of a quick way to get a general understanding of the differences. And again, we'll cover these two articles in depth in a working session. Probably within the next couple of weeks, I'll send out an invite to everyone. Encourage you to attend and participate in that working session. Any comments or
Just preliminarily, is your commission's initial review, does it indicate that the Castle Doctrine has now implicitly repealed portions of the Article 4?
We haven't gone that far, Mr. Chair. We'd like to discuss that with other members of the commission who've had actually practical experience with it. It looks like, I don't know, sure, it's possible. I think there could be some conflicts that need to be resolved. I don't know if there have ever been any conflicts addressed by the courts. It's a question I'd like to pose to our member.
Thank you. I'm aware of that.
I would just two cases. Conflict issue as it come about. I've done some research. I'd like to be looking at networking session. I know that exhibition shop around some side. But
by repealing or just inapplicability to the type of crimes?
I think, yeah, as I read the chat GPT, as I read the chat GPT summaries, I think the part it's missing is our statute. Very explicitly, the Castle Doctrine is an immunity from criminal prosecution,
Yes,
which is very significant in the case law.
Right.
And when we raise this issue, the justification defenses as affirmative defenses are a little bit different. So I actually don't think there's a repeal issue. I think, yeah, I think that they're separate circles, but I'm happy to participate in it.
In the discussions as well, practical experience when I was a prosecutor. I don't know the subsequent update, but there was an issue of when does it kick in? Because there's liability in the part of prosecution if they proceed. But when does the actual defense or when does Castle Doctrine kick in? I don't think that's clearly laid out.
Not been litigated here.
Right.
But it has been litigated for. Yeah, I without the benefit of all commission members having this for me, so I'm happy to share. I'll send it to.
So in reference to what your discussion, we are discussing, you might have to suggest how to clean up the statute, because there's an issue of, at least my time, there was an issue of when it kicked in. So the situation on the case that I was dealing with was.
The pre-charging, post-charging?
No, in terms of. The event occurred, but from prosecution's perspective, at the time, it looked like clearly they had violated the law. Defense counsel then later, at subsequent hearings, brings up the fact that, wait a second, or brings up the assertion that, wait a second, we assert Castle. Further, way past arraignment. So, I mean, and they're indicating now, well, you violated the law by prosecuting going forward. But the prosecution didn't know. So there's an issue of when does it start? When, and I don't think it's ever been addressed. When does the doctrine actually kick in? I'm putting it out there for discussion at the subcommission.
Excellent points. Thank you, Bucky and Chairman Kwan. We'll be sure to invite you to our working session. So I think that's all that I have to present, Mr. Chair. I do have a table of amendments for your summary.
Okay. Thank you. I see that the commission subcommission has done quite a bit of work, and I want to thank you for that. It must not have been simple, but we're going to go through for the plenary commission what they have suggested. So I'm going to read this out. It has been included in the packets, and we have it up on the board here. So 7.10, they're recommending amendment. 7.16, no change. 7.19, amend. 7.22, amend. 7.25, no change. 7.28, no change. 7.31, amend. 7.34, table. 7.37, no change. 7.40, amend. 7.43, amend. 7.46, amend. 7.49, amend. 7.52, no change. 7.55, amend. 7.58, no change. 7.61, no change. 7.64, amend. 7.67, amend. 7.70, amend. 7.73, amend. Article 4, justification, table. Article 5, Castle Doctrine, table. All right. Does that properly summarize the recommendation of the subcommission?
Yes, Mr. Chair.
Motion.
I move that we adopt the proposed amendments and no change and tabling up status of those laws.
Okay, that's to be moved and accepted to the final reading file.
That's correct. It's fine.
It has been seconded? Thank you. Any opposed? There being none, the amendment, repeal, and tabling suggestions submitted by Judge Secola's subcommission is hereby moved to the final reading file and or tabled as suggested. Thank you very much. Thank you very much. At this point, we are now going to move to the next section. Okay, please go to slide 58, please. We next have the report from the subcommission on crimes related to property. Mr. Tadinko, you have the floor, sir. Thank you.
Thank you, Mr. Judge Kwan. I'm going to turn this over to our subcommittee member, William Bucky Brennan, who will do the presentation on this PowerPoint.
Thanks, everybody. I hope you can hear me. And if you have any questions as we go through, please just stop me. I'll try to be quick. So we've just been keeping a tab of what our subcommission has been assigned and what we have remaining. I think criminal procedure is handling chapter 4 though, so we may remove that from our list. If I could get the next slide. So for today, on the first bullet, we previously put before the commission some grading recommendations in various chapters. We presented those by table. We thought it would simplify things, and the commission has, for the most part, approved our recommendations, but the commission staff has asked us to reduce our recommendations to the actual changes in the statute rather than just the tables, just to make it very clear the action the commission is taking. I'd just like to thank Serge and Renee for helping us put these together, the actual statutory amendments. So that'll be the first part of our presentation. The second part will be our recommendations to the firearms statute. If I could get the next slide again. So we previously made a recommendation as to criminal mischief grading. A question was raised, I believe it was by attorney Christine Tenorio, just because our previous statute had grading only for criminal mischief related to insurance fraud. So we presented it as a table, just reflecting our research of other MPC jurisdictions and common law jurisdictions. And so what we would propose is on the next slide. I know it was previously voted on, but again, this is how the statute would actually be changed. Rather than having a base misdemeanor criminal mischief crime that's aggravated by specific circumstances, we are proposing, as we have in past meetings, that criminal mischief in Guam be graded solely by value of pecuniary loss caused or intended to be caused. And that's what's reflected here. A table was previously put before the commission in February and approved. In full candor, I think there were 2 votes against. That was Mr. Morrison and Mr. Cunliffe. So Mr. Chair, I think rather than do it by table, I would offer this as the iteration of the actual statutory amendment we recommend.
May I make a comment?
Yes.
It's not to be difficult. I know I'm the one that's always commenting on this. So the only issue about the way that it's worded now, it appears to change the substance of how this conduct would be charged. Because right now, we focus on the intentional damaging of the property, and then the valuation comes later. Here, we are going to have to prove that you actually intended to cause some type of a monetary amount. So actually, I think that personally, it would accomplish the goals if we left it at intentionally damage the property of another, and the amount involved is less than or equal to X amount. Similar to the way that theft is graded, because that's the way theft is graded. It's not that you intended to steal property that was worth this amount. It's that you did steal the property and it ended up being worth this amount. And even if you were to disagree and keep the language as is right now, we're gonna need a mens rea for the initial cause. Because it's normally, when we do mens rea, it's normally recklessly cause or attempt to cause. In this, the only mens rea you can really have here is negligent or reckless. So that needs to be addressed there. But I do not think that it should, when we were talking about the gradations, I had agreed because I thought it would be more akin to the amount involved and not the mens rea of the person trying to damage a particular monetary amount worth of items.
Yeah, so if we could go back one slide, I think correct. So this, though, I think I understand the issue, and I think part of the issue is we try to keep as much of the existing statute while just grading it. I do see the issue that Christine's talking about, because it goes to the intentional, the criminal mischief intended to cause insurance fraud. That's where we put the grading in. So we just kind of added the grading language. I actually agree with her on that point, that if we address 3450, which defines criminal mischief and takes out, the specific circumstances, 3460 should just be then based on value, not intention to cause that. So I see the point, Christine. I guess that's what I'm trying to. Yeah.
So. The one language has intended to cause, so I need to strike that.
Yeah, it's just cause. I think she said
Cause
pecuniary loss.
Yeah. Just cause doesn't require a mens rea, just. Yeah, it doesn't require, it's a result. You don't have to say, I only, if two items are present, one is $5,001, the other is $2,500. I want to break the $5,001.
Right.
You want to get rid of that. Yeah, that's what I'm saying. You don't need the or is intended to cause, but the result causes the pecuniary loss. Is where the gradation comes.
Right.
I think it's just a matter of we were just adding it to the existing statute.
Yeah, no, I understand what you're saying. I mean, I think that cleans it up if we take out or is intended to cause. It's just causes pecuniary. So if you can't put the break the prices out there, oh, what, sorry, the price is out there. Yeah. It's a result. That's an element as opposed to mens rea element. So the suggested change at this point, on top of it, you see that now is to strike out or is intended. Yeah. So if I have two items in front of me, one is $50, one is $5,000, and I break the one on the left, and it happens to be $5,000, I'm not responsible for a higher bid price. Right. Just the way it is. I didn't know or well. Okay, I got it.
I think though, instead of, my issue is the actual verb cause. Maybe if we just put, and if the defendant's conduct results in a pecuniary loss of 5,000. Anytime we put the word cause, the Supreme Court gets on us for not proving a mens rea for every single type of causation.
I agree that results in is, because I call it old school result element, so as a.
This is Randy Cunliffe. I mean, if you think you can have negligent or recklessness, then every automobile accident is going to be criminal mischief.
Right.
Okay, so the consensus or theory is it should be a violation of 3450 is a second-degree felony if the defendant's conduct results in pecuniary loss of $5,000 or more. And that'll. And that should be throughout. Across all four. That should be throughout the, all the chains. Yeah, all the chain, throughout wherever you see the phrase is intended to cause. 32 are you in agreement with that?
Yes, thank you.
Anybody else have any issues with what is being proposed at this point in time?
Assistant Public Defender Brian Eggleston, I want to clarify just what exactly the meaning of that would be, because I think it's clear that there does need to be a mens rea element. If someone reasonably believes that the action they're taking is only going to cause $5 worth of damage, it would seem incredibly unfair to make them guilty of a second-degree felony just because they happen to be wrong. That seems like so. It would how would the mens rea element fit into this?
So it would still be that the focus is that you intended to damage the property without monetary amount. It's the way that we've currently been charging it. It does not matter what the amount is as long as you intended to damage the property. So that's the mens rea.
So, I mean, that seems to suggest that someone who reasonably believes the damage they're causing is only going to be $5 worth could actually get charged with a second-degree felony and found guilty just based on the fact that they happen to be wrong, though reasonable. To me, at least, that seems like that can't be correct.
Well, that is what is being proposed by the subcommission at this point in time.
Okay, in that case, I think I would object to the language on the basis that it needs to have a mens rea element with respect to the amount of loss.
And just to be clear, we knew this would be a contentious one. I'm recommending excising it and voting on it individually. But again, our recommendation is prompted by looking at, and we presented this previously, right? And so completely understand the point, but the other MPC jurisdictions in California and seeing they all use similar grading after, as Attorney Tenorio was pointing out, after the damage is caused, right? They look at the grading, or excuse me, the penalties based on the value. So yeah, we knew this would be contentious. Let's put it that way.
Okay, so your subcommission is putting it forward at this point in time. The plenary.
And our research is in the February 24 meeting.
Yes.
Yeah, the survey we did.
Okay, so we'll take a vote on that at the end of this presentation. Go ahead.
As amended, then we'll go to the next slide. Okay, so this one, again, it's just grading, updating the grading based on issuance of dishonored checks and adding, again, a second-degree felony. When we compare it to other jurisdictions, it was progressive, and the values were different from Guam. So we're putting this before the commission as well, updating. We previously presented this as a table, and the commission helped us fit it into the actual statutory change that will result. So that is 4630. We could have the next slide.
But I'm sorry, this is Serge. Do you want to mention that you are striking the?
Oh, sure, yeah. Also, our subcommission, as we went through our chapters, we found a lot of variation in when grading was done. So it would say things like, as you see in the statute, guilty of a petty misdemeanor, punishable by imprisonment for not more than 60 days, or by payment of a fine of not more than 500. So we've just tried to make it consistent and just eliminate any references so that sentencing would be based on the disposition of offender statute in the Code of Criminal Procedure under Title 8. So that's kind of what you'll see across them. We could get the next slide. Fraudulent use of credit cards. Again, we just again updated, or we're proposing an update to the grading, adding a second-degree felony based on the larger amounts. Next slide. 4635, 4680. Again, adding grading to the statute. Yeah, this would go all the way down to petty misdemeanor, again, depending on value. Next slide. So for mortgage fraud, the reason for this statute is as it existed previously, mortgage fraud was simply classified as a second degree. Was classified, with grading, but we tried to envision situations where you would actually have mortgage fraud for less than $1,000, between $300 and $1,000, and we recommend that it just be a secondary felony based on the values. At least the factual circumstances that were defined as mortgage fraud. Next slide. The commission staff asked that we clarify where we had moved some language in the statute and a previous recommendation under the animal cruelty and animal negligence statute. So I have it on mine as struck.
Oh, struck.
Yeah.
Okay,
That
okay.
red language here should be struck.
I apologize.
Should be a line on that red.
Yeah.
Through all of that.
Okay,
Yeah, so just sorry, just to be clear, this physical injury definition appeared, I believe it was in the animal negligence and animal abuse statute. But we previously had cleaned those statutes up, resulting in striking this language. So it would appear only in
Yeah.
sorry, these are a little out of context, because we just were asked to clarify this.
I'm
one
seeing
statute.
this. That's what.
Yeah, so we're recommending the red language here be struck.
out.
Should be a line through it.
Yeah, and this is consistent with our previous recommendations. So I apologize, it's a bit out of context, but the commission staff said you weren't as clear on a vote on this specific item at the February. So we're recommending 7015J be amended to strike the language shown in red for those on Zoom. We have it struck here in our packets.
I apologize for that. It's a technical glitch on my part.
So if you would just read it the way it's supposed to be read, that's it.
Here we have.
Just leave it.
Yeah, so we would, 7015J would define physical injury as physical trauma, impairment of condition, or pain or illness produced by violence or by a thermal or chemical agent.
Here.
Period.
Well, it was, I mean, how do you prove that somebody made them get parasites? That was part of the discussion.
You get the next slide. Okay, so the, on the firearm statute, we just wanted to highlight, the more recent Supreme Court case, as Bruin, we copied the syllabus and holding from the Supreme Court opinion here. The reason we just added this is we do have one recommended change, but we wanted to highlight for the commission that this is a topical area. There's lots of litigation in, other jurisdictions, be it in the district court or already at the circuit court level about, current firearm regulations in a post-Bruin world. We think there are more changes coming down the pipe, and the most the commission could do at this point is just highlight, perhaps for the legislature, that this is a sort of fluid area. Our one change, the next slide, would be on the exceptional, sorry, next, yeah, would be on the exceptional cause requirement in our law. We think this is consistent with what was struck down in Boone. And so we would recommend amending 6109 to remove the exceptional cause requirement for a concealed carry permit. That would be the language. I don't know why it's red. But, oh, I understand. So it's red. The language you see that's struck in red was moved to make the statute still be consistent and clean it up after we repealed the exceptional cause requirement. We could get the next slide. So this one was brought up by our subcommission chairman in his time as a chief prosecutor. There was a specific fact pattern that we were trying to address by this proposed amendment.
This just had to do with our many military members who PCS here, and even though they get the notices about having to register their get both a license as well as register their weapons, they run into a lot of problems, especially up at GPD. And they're like 2 years later and they go, I didn't know I had to register my weapons, and I didn't know I have a license and all of that. So, and what would happen is they'd end up having to give it up, forfeit it voluntarily.
Yes.
So as opposed to being charged, because at that point they just admitted to GPD that they didn't have it registered. So we try to provide some wiggle room and some room for them to have longer time to register and propose, and that's the purpose of this language. And please feel free to weigh in here. Folks have a different view of how that should be done, but it was our experience. We were always getting calls about, should we charge them? Should we not charge them? Back in the day, and so that's part of why I was a little confused when somebody gives their firearm to law enforcement officer. Where does that state that you do? Exactly. A little committing a legal violation, I just give the police officer my guns and what happens to me? Nobody in the committee can answer that. And I know by going up to I was up at Revenue Tax the other day for business license renewal, and it said, had a note there saying, every day you delinquent on renewing the business license is $1. So if you, 1 year, $365. Having said that, we're $10 per day for not registering, and I wonder if it should be $1 per day. Well, it's just, $10 per day for get a year, and it's $3,650. Well, yeah, you can take my guns, I'll just buy some new ones, you know?
That's a good one. We put that in there based on money suggestion. In other words, you're late. We know you're an upstanding citizen. You've been here 2 years. You know, do we make them just pay the 2,000, instead of charging them the car?
Or surrender.
Or surrender, yeah. So there's no, when you get charged, it does get forfeited, right? In this case, this is a registration of the firearms, of course, that's important. So this was kind of a workaround to see, get that there. I don't think we have any surrender language.
No, it's just something that.
But common law?
So I can fill some of that in. What was happening at GPD at the time was you had service members who, the bases have requirements that a service member cannot have the weapon in their house. So once they PCS2, when they come to Guam, they have to turn in the weapon to the command armory. And they're told you have to register, but they forget, and they turn in the weapon to the command armory. And it stays there. At that point, they're trying to leave. They then go get the weapon that's been there for 3 years. They pull it out. At that point, they say, well, wait a second, where's your registration? Then they get in trouble. And then what was happening in the past was that they would contact GPD. GPD would then take it, hold it in custody, and then we'd contact the AG's office. And the AG's office, the standard procedure at the time was, okay, if he surrenders it, we'll do a no prosecution. We'll decline prosecution. And then GPD will keep it or destroy it. And then the person can leave with the no prosecution document. I believe that's still on the table. If the person doesn't want to pay the $3,000, then.
It was the workaround.
Yeah.
But, so we were just trying to put some language in there to figure out how to codify. But, so we thought instead, if you show up after 2 years, kind of like the revenue tax, you don't get your license, you get what? You pay the late registration penalty. So we were trying to work that into this as sort of a late registration penalty. And the $10, hey, that's $1. I have no. Actually, we just give up the $10. $1 a day seems to lessen the importance of registration. So I think $10 a day. Especially if that weapon's that important for them,
As long as the military member knows.
Well, and they usually told us.
Member orientation.
They are.
They are given this, we've seen their notices to the members coming in saying, well, law, especially through the customs. All laws, this and this, so if we put this in law, then they know that, okay, if I don't do this, I get a fine. Again, like a car or driver's license registration. So that's the point of that. So anyway.
Any comments? There being none? William?
I think that's it. Yeah, that's it for our next subcommission recommendations.
Excellent work by that subcommission. I'm just gonna recap it at this point.
Wait, you didn't do this. Sorry, there was one more. Base period. Yeah, we also addressed that.
So this was just to address the amendment we made in the prior statute to make it consistent with the immediate succeeding.
Okay. So let me recap by table format. So the representations are as follows. The subcommission is recommending the following.
3450, they're recommending amending it. 3460, they're recommending amend. 4630, amend. 4635, amend. 4680, amend. 46103, amend. 70.15, amend. 60.109, amend. 60.110, amend. And 6110.1, amend. I do note that there was some objection to 3460, the amendment proposed. So at this point, I guess we'll do this one by one.
The objection is to 50 and 60.
34, 15, 60, okay. So we'll do this one by one. So is there a motion to accept the changes as follows, submissions? Anybody motioning? Well, we're gonna do, we'll take the motion and then we'll go through each one. Is there a motion to accept the subcommissions? Okay, is there a second? Okay, so let us take them one by one. 3450, all those in favor of acceptance of the subcommission's recommendation on 3450 and moving to the final reading file, please say aye.
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 All those who object to it, please say nay. All right. 3460, all those in favor of moving that to the final reading file, say aye.
Aye. Aye.
Opposed, say nay. Mr. Eggleston?
I'm a non-voting member.
Thank you. Thank you very much. Sorry. Next one is 4630. All those in favor? Aye.
Aye.
Aye. Aye.
Any opposed? Say nay. 4635. All those in favor? Aye.
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 All those opposed? Nay. Next one, 4680. All those in favor? Aye.
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 Any opposed, please say nay. 46103. All those in favor? Aye.
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 Opposed, say nay. Chapter 70.15. All those in favor? Aye.
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 Opposed, nay. 6109. All those in favor? Aye.
Aye.
Aye. Aye.
Opposed, nay. 60.110. All those in favor? Aye.
Aye. Aye.
Aye. Aye.
Opposed, nay. Last one, 6110.1. All those in favor? Aye.
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 Any opposed? Nay. There being none, that is being, those recommendations are being moved to the final reading file. Thank you very much. The subcommission was quite a bit of work. I want to thank you for your efforts on that one. All right. Could please slide to 74. That's completed. Next slide. The next notice of meeting is going to be Thursday, August 22nd at noon, tentative. August 22nd at noon. Let's move to the next item of the agenda. Item 8. Are there any comments from anyone?
This is just, it's not on the agenda, but will the commission be given an opportunity? I would like to express support for the extension of funding and time for the commission. That can be put on the August meeting's agenda, or if we, if there's some way we as a commission can make that expression of our support. I would. Yeah, I know it's
Yeah.
not,
Good one.
Thanks for raising that. I completely forgot to mention that
We didn't forget
during my update. No.
You just keep it behind you.
So there may be an opportunity for the commission to present an update to certain members of the legislature And I did anticipate inviting, all the members of the commission
And
to
ex officio.
attend. So yes, indeed, if we do have that opportunity to, appear before the legislature on the amendment, and our budget, then I'll let everybody know, whatever the context that might be.
Any other comments?
Well, I'm sure I'll do what we want in our personal capacity, but it might carry some weight as a commission. Express that collectively before the legislature votes on it.
I submitted as written.
Any other comments? I want to thank all the members as well as the ex officio members. As I said, what you're doing now is going to echo through time and will affect how we practice law and how it is applied on island for generations at this point. I want to thank you for your work. I know it's difficult. I know you have a lot of demands on your time, and thank you very much. Any other comment? All right. At this point, as I said, the notice of next meeting is August 22nd at noon. May I have a motion to adjourn? Seconded? Any opposed? Thank you all. Have a good day. Thank you very much.
Thanks, everyone.
Thanks so much.
We're not doing 13.
We did 4A.
No, but you guys did
13.
Yeah. No, is that's you guys, no, that's, it was listed under ours, but. It's everybody, but.